Chapter 3, a bit more about case law and how it works. 3.1, does the law come from a statute or a case? We've already established that in New Zealand, law comes from both cases and statutes. So how do you know whether any given law comes from a statute or a case? There's actually no clear method or big database that shows you whether a law comes from a statute or a case. To add to the confusion, sometimes one law can be found partly in statutes and partly in cases. Generally, to find out where a law comes from, I recommend reading a few pages from a major textbook on the subject. Most textbooks will give you an overview of where the law comes from in any given area. Also, a textbook will normally tell you what the major cases are in that area of law. And in the major cases, the judges will normally go through an overview of where to find that law. However, you do start learning the general places of where to find laws over time. For example, criminal law is almost always found in statutes. Also, another example is that laws relating to torts are generally found in cases. 3.2, how do you know what case is the one that sets the precedent? There's also no big database or exact method for figuring this out. A recent textbook on the subject will likely tell you what the precedent-setting case is for that topic. Or if you can't find a textbook, if you type the name of the law like negligence law into a legal database like LexisNexis and read through a few cases that come up, the judges in those cases will normally say what the precedent-setting cases are for that topic. 3.3, how do you find the law within a case? Let's say that you've found out that a particular law comes from cases and you've found the precedent-setting case. Awesome. So after that, how do you find the law within that case? You guessed it, there's no exact method or easy rule for finding the law within a case. First of all, the law within a case is sometimes called the rule of a case or the ratio decidendi, which is often shortened to ratio. Basically, ratio means the main law in a case. In a case, there's always one or more main problem that a judge is making a decision on. The rule of a case is the decision a judge makes about that main problem that the case is about. To find the rule, some cases have a little summary at the top saying what the case is about and what the rule is. That's super handy if you have that. However, the best way to find the rule in a case is to read through the whole case and see what the main legal problem was and what the judge's decision was in relation to that main legal problem. In cases, a judge might write a lot about the history of that law or the law and how it applies overseas and other ideas. But if these statements do not solve the main problem in that case, they're just general chit-chat, which is sometimes called obiter dicta. The rule of a case is only what a judge decides in relation to the main problem or issue of the case. So it's the main decision of the case and not the chit-chat. For example, let's say someone got fired from their job. That person then sues their boss and says they were fired unfairly. The main issue in the case would be, was that person fired fairly or unfairly? The rule of the case would be related to that main issue, whether that person was fired fairly or unfairly. To find the rule of a case practically, keep an eye out for a judge using words like to conclude or the rule is or my decision is or something like that. A hack I sometimes use is I press Control F and I try to find a word like decision, overall, main, rule, ratio, conclusion, or to conclude. But generally, it's best practice to read through the whole case and see what the judge or judges ruled in relation to the main issue or question of law being decided in that case. 3.4, distinguishing cases. Let's say you're a lawyer and a case exists that's precedent setting, but it doesn't help your client win their case. What lawyers often do is try to argue that a particular case that sets precedent doesn't apply to their client's case. They do this by saying that the facts of their client's case are different to the facts in the precedent-setting case. This is called distinguishing cases. The lawyer is saying that the judge can make her own decision about the case and not be bound to follow earlier precedent because the facts are different and therefore the law is not the same and doesn't apply. In chapters 2 and 3, we looked at one source of law in New Zealand, which was cases. In the next chapter, we're going to look at another source of law, which is statutes, or law made by Parliament. See you soon.